Welcome to Employment Law This Week. I'm George Whipple. Our top story, a cause of action under Illinois' stringent biometric privacy law does not require a plaintiff to show that they suffered actual harm. The state Supreme Court has held that the only requirement is proof of a violation of the individual's rights. The case in question involved a teenager who was fingerprinted when he bought a season pass to an amusement park. We spoke to Jimmy O, a member of Epstein Becker Green, about the implications of this decision for employers.
The Illinois Supreme Court's recent decision in this case against Six Flags is notable because it's the first decision from a state Supreme Court that holds that you can sue under a Biometric Privacy Act without proving actual damages. In Illinois, there's a private right of action, and the plaintiffs' bar have picked up on that. They have been filing these lawsuits, but they have been somewhat in a holding pattern, waiting to see what would happen in this case, where the Supreme Court was asked to decide, can you actually pursue a lawsuit without having proven actual injury? And now that the Illinois Supreme Court has said yes, that it's a very notable decision, is creating a lot of attention because it is going to continue the onslaught of these types of cases in Illinois.
The Supreme Court limits court powers to determine whether a case can be arbitrated. Writing for the majority in his first opinion on the court, Justice Kavanaugh found that a court cannot disregard an agreement that grants arbitrators the authority to determine whether a case is arbitrable. The issue at hand was whether under the Federal Arbitration Act, a court may ignore this sort of provision if it finds the argument for arbitration to be wholly groundless. Writing for a unanimous court, Justice Kavanaugh said courts could not rewrite the statute passed by Congress and signed by the President. The DOL moves forward on its new overtime rule. The Department of Labor has sent the proposed new rule to the Office of Management and Budget, the final requirement before publication. The DOL originally proposed a new overtime rule in May 2016 at the end of the Obama administration. That rule was invalidated by a federal court in Texas shortly before it would have taken effect. The new rule is expected to raise the current minimum salary for white-collar exemptions from $455 per week and could change the streamlined tests for other exemptions under the FLSA. The NLRB reinstates its test for independent contractor classification. The National Labor Relations Board has overturned its own 2014 decision, making it easier for certain workers to be classified as independent contractors under the NLRA. The revised standard, which the board will now use, allows for the consideration of entrepreneurial opportunity among other factors, while the 2014 standard did not. Additionally, the public comment period for the board's proposed rule establishing new joint employer standards concluded on January 28th, with replies now due by February 11th. Chairman John Ring has indicated that the board is also looking at additional rulemaking. And that brings us to our tip of the week. Ben Pring, co-founder and managing director of Cognizant's Center for the Future of Work, is here with some advice on artificial intelligence in the workplace.
This isn't science fiction anymore. This isn't kind of Hollywood. This is real. It's happening now. And it's an important moment in which people who are doing that work, whether you're leading a team or whether you're kind of in the midst of that work, it's an important time for people to be paying attention. We sometimes talk about the fact that we think really the formula for the future of work is X plus AI. X representing whatever it is you do, whether you're a lawyer, whether you're a teacher, whether you're a doctor, that's the X. Inject AI into that, add AI into that, X plus AI. And that's how you get to the next performance threshold, the next level of productivity in whatever it is you do. But we also talk about the fact that it's not technology for technology's sake that really ultimately we're all interested in. It's changing work for the better, making better work.
Thanks, Ben. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.